Okay, so we are now ready to get started, and this is an MS NeuroTV program. And we started MS NeuroTV a long time ago, and we're just continuing through the epidemic or pandemic or whatever you want to call it. It'll be around forever. So what name do you want to call it? Okay. Next we have me. So I am Stuart Schlossman, and I guess most of you that are online already know who I am. And if you don't, well, just tune in more often and you'll get to know. Okay. So tonight's program is supported by BIOGEN, and we want to thank BIOGEN for all that they are doing to support the MS Views and News programs. Tonight's program, we have special guest Craig Dorne, and Craig M. Dorne is an attorney from Coral Gables, Florida. He has what they call an AV rating. That's Alpha Victor rating, making him a very, very skilled, well-known, highly recognizable attorney, especially in Florida. And I'm sure he, will work wherever it might be needed. So tonight's program is called Caregiver Rights and Financial Responsibilities. And Craig is going to speak with you about some very important things that, maybe that you're just an MS patient. Maybe you'll be able to inform your caregivers about this program afterwards, people people you care about, people that you want to know more about you and what might be needed about you going forward. So after Craig's going to speak for about 30 minutes, and after his talk, we're going to do a Q&A, and the Q&A will be, again, whatever you guys want to ask about what he is presenting about. Please don't ask any medical questions because Craig Dorne is not a doctor of any type, okay? Like I said, he's got a degree, but it is in law. Thank you, and Craig, take it away.
All right, I want to thank everybody for joining me tonight. It's my first virtual presentation. I've done a few for MS Views and News over the years in person. So a little bit of a learning process here also for me. Today I really want to talk to you about caregiver rights in financial and medical care planning. It's a topic, I guess, amongst the more morbid conversations to have because you have to think about what's inevitable in life. But the problem is I want to make sure that everybody thinks about the things they can do in advance so that we can make sure that you have the ability to actually make your own decisions. I'm sure many of you have been either admitted to a hospital or been in a doctor's office where they may give you some information to fill out, which may have some of the documents. But I'm sure you all can realize that if you did do that, it was probably when you first became a patient. And if I was to actually look at the documents even in my own doctor's office, since I've been using the same one for over 20 years, they may not say what you wanted to say now. Those doctors may honor a request from a family member, but they may also not. So it's really important to sit down and make sure that you get the documents done and completed to make sure that they really say what it is that you want to say. Don't worry, you don't want to actually have to make many of these decisions when you're admitted to a hospital, in particular if you're there on an emergency basis. And you want to make sure that the providers know who you want to make that decision. There's also a major difference in the documents that you create with a lawyer or a professional versus one that a doctor may give to you. Or the worst case scenario, when you don't have any of the documents completed, and then the court has to make that decision for you. Because there are going to be times, and I can give, as I'm going along, I'll give some of the worst case scenarios of things that I've seen in life. But we don't want to sit down and have people wonder what it is that you want to do, or wonder who you want to make the decisions for you. Because if you prepare the documents, those decisions must be honored. But if you don't create the documents, as I said, then it's a decision that would be leading to the court system, in which case I can give my worst case scenario that you may have here. Let's say that you got divorced and the last document you had was giving that power to your ex-spouse. Or let's take another example. You have an estranged child that's trying to make a decision for you. These are things that I've seen, and actually not too long ago, I actually got called by a child whose father was in a hospital, and the wife that he was in the process of divorcing was the one making the medical decisions and not actually even allowing the child to see the parent in the hospital. So we had to get documents done on an emergency basis in order to sit down and get the child the rights, which is not really something that you want to have to do on an emergency basis. let alone when you're in the middle of a hospital. Also realize that many of the documents you might be getting online may not actually be legally sufficient or give all of the rights. Let's have a little conversation on something that I'm sure almost everybody's familiar with now, but it's still relatively new in the medical field, the concept of HIPAA, which deals with privacy. Many of the legal forms that were created, such as a healthcare power of attorney or a healthcare surrogate form, give somebody the ability to make a medical decision. But the problem comes in is, wouldn't you like to have the right to see the medical records in order to make a decision? So that's some of the types of things that we're going to talk about as we go forward. Now, there are many things you can do as part of your financial planning. And these are the things I love to talk about, which are the absolute free things. What is it that you have the ability to do as part of an estate plan that costs you absolutely nothing? Well, you can sit down and go to your bank, deal with your bank accounts, your certificates of deposit, your brokerage accounts, your retirement accounts, and your life insurance policies. Many of you don't check on these things very often. Most people don't. You can sit down and designate beneficiaries on your bank accounts, your certificates of deposit. What does that mean? That means you're taking things out of your estate where somebody just goes to the bank, presents a death certificate, and now those documents and those funds have the ability to be transferred. It can be the securities in your brokerage accounts. It can be your bank account. Most people think, well, in order for me to protect myself, I should go to my bank and add somebody else onto my account. You can do that, but then what does that mean? You've now made that person a co-owner of your account. That means even without your permission, they can go to the bank and take out your money. The better thing to do is have what's called a POD, a paid upon death clause, or a beneficiary designation on your accounts. That means they can only have the access to your funds. It doesn't need to go through probate, and you can take care of those things by just making a designation on your bank account, your CDs, your brokerage accounts, retirement accounts, and your life insurance policies. But the mere fact that you tell the bank to do it doesn't mean that the bank actually does it. Check on those things, confirm them. I'm dealing with somebody, again, just recently, who I know had a beneficiary designation on an account, but the bank doesn't have a record of it. Bank records, especially when all the banks get transferred, don't necessarily go forward, so it's good to periodically check on these things and make sure they're done. I can give you my own personal thing, which has happened to me now twice. Twice I've been contacted by my bank saying they can't even find my signature card on my checking account. Not a very good thing. So if they can't find my signature card, that also means they can't find my beneficiary designation. So it's good periodically to get in touch with your banks, your brokerage companies, and everybody else to make sure that everything is truly the way that you want it. Also make sure even on your life insurance policies that the beneficiaries are still the way that you want them. So I encourage every one of you, tomorrow, the next day, don't wait. Speak with your banks, speak with whoever you have your securities with or anything along those lines, and make sure that the documents say what you want. Now the things, unfortunately, that do cost money. Those are wills, trusts, advanced directives, proxies, powers of attorney. These are documents that I'm going to want to go forward and discuss each in a little bit of detail, but they're very important to make sure that you have them stating what it is that you want to say. When you prepare those documents, you've got to prepare them knowingly and figure out who is the best person for each of the documents. I always talk about the example saying there's people that are good in certain roles. One is the person that's good with numbers. That's somebody that you would want to sit down and take care of your financial affairs. That would be the person you'd want to take care of distributing your money and make sure that things are done correctly. Now, I'm sure everybody that's listening right now can think of people that are very good handling money, but that you may not want to take care of your children. So you can have a guardian inside of a will appointed for taking care of your children, but that doesn't mean you have to give the person the access to the money. You can divide the roles. I think it's very important to divide the roles to the people that handle things the best. So as you go through the things, think and discuss with the professionals that will help you prepare the documents, saying, okay, who is good for this? And when you decide for a person, it's also important to think of a secondary person, and maybe even a third person as well, because people may pass away, and before you update your documents, somebody that may say yes, if you discuss it with them in advance, may change their mind. So you know what, I really don't want that responsibility. So pick a first person, pick a second person, and if you can, even pick a third, and the documents can be drafted to go in that type of an order. When you pick the people, especially let's think about somebody that wants to sit down and make a healthcare decision for you, it should be the person that's, one, going to honor your wishes, two, be capable of really understanding and dealing with such people as your insurance companies. And they should even have some familiarity with the FMLA, because they may have rights to it, and you may have rights under the FMLA as well, to be able to deal with employers and make sure that you have the ability at some point in time, if you may need to miss work or they miss work, what are some of their rights? Remember, the documents are what's important. That's what's going to help everybody determine what the roles of everybody are. Legal documents are required to give a power. If you want somebody to have a power of attorney over you, you need to have a document that gives that person the power of attorney. If you want that person to sit down and be able to make a medical decision for you, that's the person you want to designate on your healthcare surrogate form. I don't want people to get caught up so much on the title of a document. A power of attorney generally is a document that's given which gives the person the power to act on behalf of that person. A durable power of attorney may only give the ability to act on behalf of that person, but may also give medical rights. So you really have to make sure you understand what the documents say. And remember, if you don't have the documents created, you may need to have a court take action. Let's say somebody's involved in an accident and they're temporarily disabled. They can't do something. Well, who's going to be the person to be able to write your check to pay your mortgage, your car payment, your rent payment, and whatever else it is? You want to make sure that you have the power of attorney given to somebody so that they can make those decisions. Without those, it can't really be done. You also want to make sure that the person will honor your request. You may need to make some uncomfortable decisions. And what do I mean by uncomfortable decisions? Well, if you have, let's say, a spouse or a child who would be usually the person that would be chosen to make a medical decision for you, will that person honor your desire? Or will they do what they wish? I can tell you for a number of times we've had this conversation with people, and it's one of my most difficult decisions, saying, well, you're saying you want so-and-so to be your healthcare surrogate. Will that person do what you want or what they want? Because it's not only for the healthcare surrogate, let's say it's for the living will, meaning the pulling of the plug and things along those lines. There are people that will not honor your wish for religious reasons or other reasons. So make sure you have a conversation with the person, or make sure you truly understand what that person will do to make sure that they'll comply with what it is that you want to do. Now, who can you select? You can select anybody to do these decisions for you. You can give anybody you want a power of attorney. You can make anybody you want your healthcare surrogate, as long as that person is of an age of majority. Now, there are some limitations with some of the documents. Let's say, for example, a will, where the person needs to be an immediate family member or reside in the state in order to give them the power to be the personal representative of the estate. So you may have a best friend who lives in, let's say, New York, and you live in Florida. That person cannot be your personal representative, at least under Florida law. So again, when you make these decisions, that's why it's important to do them with professional advisors and not what I say, create and do some of these forms from online forms. You need to make sure that the forms will comply with the law. And many of these online forms are what we call fill in the blank. They don't give you the ability to really make modifications, and they may not trigger you with proper questions to make sure you're choosing somebody that can do the power. So powers of attorney, healthcare surrogates don't really have those limitations, but wills do have some limitations, so be careful. If you do not have immediate family members, it's essential for you to sit down and create the documents, because then nobody's going to have the ability to speak for you. Your best friend, that may be the person that you trust the most to take care of making the decisions for you, there's no saying that a hospital is going to honor the wishes of your best friend, saying, well, what is your relationship with the person? No, it's my best friend. That's not going to work in a hospital-based setting. In many cases, if somebody gets admitted on an emergency basis, they don't have the ability to sit down and give all those notifications to you at the time of admission. So I encourage everybody really to take the time. It's not that expensive to contact a professional representative to sit down and help you create the documents to lawfully appoint people to do things on your behalf. Now let's talk about some basic estate planning. The most typical types of documents from part of your estate plan are going to be a will or a trust. The will appoint a personal representative, which gives that person power only after your death. Prior to your passing, in creation of a will, a personal representative has zero power. They cannot do anything on your behalf. The will only becomes effective upon the passing of the person. So what do you do before the ability to have somebody act on your behalf? Well, you can transfer your assets into a trust. A trust can work during a person's lifetime, and it also may operate and affect things after your death. Again, important things to discuss with a professional representative to help you guide you with what is best for what your wishes are. I would encourage anybody that doesn't decide to transfer their assets into a trust during their lifetime to have a will that deals with things after your passing. But in addition to the will, have a power of attorney with somebody that you trust to sit down and act on your behalf in the event you're not able to do things before your passing. Next, we have a healthcare surrogate form, another important part of a estate plan. This gives somebody the ability to make medical decisions. A healthcare surrogate form does not give the person the ability to act on your bank accounts, does not give them the power to do anything other than make a medical decision. The biggest problem I have with many healthcare surrogate forms that are out there, and it's actually the vast majority of the ones I see that are not prepared by attorneys, is it gives the ability to make a medical decision, but it does not give the ability for that medical provider to actually share the medical records with the person that's making the medical decisions. Well, let's say you're diagnosed with cancer. Wouldn't it be nice for that personal representative to see for himself or herself what those medical records actually say? To not only to be able to talk to the oncologist in the cancer situation, but also to be able to see the reports from the radiologist and see what they say rather than just having the doctor interpret it for you. The medical decisions are in the healthcare surrogate form. The power of attorney form, as I discussed before, gives the person the ability to make the financial decisions. Now, that power of attorney form is what I call the most dangerous document that has ever been created. Why do I call it the most dangerous document? Because a power of attorney form typically will give somebody the power to act on your behalf. It does not require you to be disabled at the time. That means a person with a power of attorney form may go to your bank account, may change beneficiary designations, may close out your account and take all your money away. So you really want to make sure that you give that power to somebody that you trust, It may also be important that you don't give that document to the person prior to them needing to use that document. Now, I'm not saying to lock it in your safe, or especially to put it in a safety deposit box. I do not encourage you to put any of these documents in a safety deposit box unless the person you trust to give all these power to also has the ability as being an authorized signer on your safety deposit box. Because if it's in your safety deposit box, how do they get into it in the event you're disabled? These power of attorney forms can be very broad, they can be very narrow. If any of you have ever sold a car, you've signed a power of attorney form to the dealership to give them the ability to prepare documents on your behalf. It's a very limited power of attorney. You may give an attorney the ability to sign some documents on your behalf at a real estate closing. Very limited power of attorney. A power of attorney form can give the ability to go change your life insurance policy. It can give the ability to go sell your real property. It can give the ability to go close out your bank account. It can give the ability to take all of your stocks from Merrill Lynch or Smith Barney or whoever has your stocks and sell them and take the money. So again, know what you are signing. I have power of attorney forms that I use that actually have, like, I can't even tell you, I never counted the number of paragraphs, but let's say 40 paragraphs, and you have to initial each of the paragraphs to say that you want to give this power and not give the other power. So they can be whatever it is that you want them to say. But make sure you truly know what you are signing when you sign one of the power of attorney forms. Next, we have advanced directives. Advanced directives can be your living will, meaning I want to have somebody act on my behalf at certain types of decisions. It's a advanced directives can be a do not resuscitate order. Again, lawyers can prepare these forms for you at a charge. You do have the ability, although I don't think the forms are the best, to maybe get some free forms on some of these things from your medical providers or from your state bar association. So if you cannot afford an attorney, that should not be a reason for you not to get documents. I would rather you have a document that's not the best than not have a document at all. So speak with your medical providers if you don't have the forms and try to get them. If you don't have a doctor that can get them for you, I would encourage you in whatever state you're in to contact your local state bar association and see if they have forms that they can provide you with or give you access to online to help you prepare and make some of these decisions on your behalf. Anybody that you're giving that power to needs to be over the age of 18. They do not need to be a family member. You can give the power to anybody over the age of 18. Realize also when you create your advanced directives that you can cancel them and you can change them at any point in time. Don't feel like you're stuck with a form because you did one. You have the right to change your mind. The most important, though, part is to make sure that when you sign the forms is that you are in a, what I'll call, sane, rational state at the time. If the person has already been given a diagnosis of Alzheimer's, now is not the time to get that form signed. Now is probably too late. Now, while that person may be capable on a given day, it makes it very easy to have somebody go contest those documents. So I don't care if you're 18, I don't care if you're 25, I don't care if you're 90. Get the forms done to make sure you have it saying what it is that you want it to say. Some of the forms are going to require you to have the forms notarized, others do not. Make sure that whatever forms you're getting comply with whatever state you're in laws. If you are currently living in the state of New York, and like many others right now, you're fleeing to the state of Florida, either permanently or temporarily, The forms will come with you, and if the forms were valid in the state you were living in at the time, the state that you move into will still be obligated to honor and comply with those forms. So don't let another lawyer say, no, you moved, so therefore you have to pay me X number of dollars. No, those forms that were valid where you created them, they're going to be valid where you moved to. You just need to make sure they still say what you want them to say. When your decisions change, it's important for you to inform your family members that are supposed to be making these decisions for you, know what the new documents say, but also, when you get the documents, provide them to your primary care doctor. If you're getting admitted to a hospital, bring a copy with you so you can give it to the hospital, rather than relying upon the forms that the hospital may give to you at the time. That's really the best way to get it done. Have them professionally done and make copies and bring them with you. Now, the living will is another scary form to be considered about. And a living will is not a required document for you to have. It's only a document if that is what your wishes are. There are people that say, no, I don't ever want to have the plug pulled. I want to fight with every last breath that I may have, whether it be my breath or an artificial breath. I don't want the plug being pulled. But if you do want to have final decisions being made about life-sustaining devices, meaning feeding tubes, respirators, and things like that, you should create a living will, which generally deals with when somebody has a terminal condition, whether they have an end-stage condition, such as renal failure or something along those lines, or they're in a persistent vegetative state. Those are the general time frames when a living will is necessary. Again, you may have the ability to get some of these forms, such as a living will. You know, the Florida Bar has free forms that are available online through the bar. But again, they are not the best forms, but they're still better than nothing, and you can get some of these forms for free. If you have the ability, I would encourage you to go to a professional to make sure you get one that says what you want. The DNR is a scary one also. It means do not resuscitate. It's something important for you to discuss with your physician when you reach a certain state, which means if the paramedics or somebody come, I have a DNR order, they do not resuscitate me. If the heart stops, they are not allowed to sit down and give CPR in order to start the heart again. A DNR is not the same thing as a living will, but it is another form that is available for you to use if you reach a certain stage in your medical conditions. Next thing I want to talk to you about is a guardianship. If you do not have a power of attorney form and you do not have a healthcare surrogate form, in order for somebody to act on your behalf with full lawful authority, the important thing that's going to have to be done is somebody is going to have to go to the court. They're going to have to open up and file a petition for guardianship to make decisions for you. That would be for medical decisions as well as financial decisions. This is what I call the worst case scenario, because in order to get these things done, doctors are going to have to testify and a whole bunch of things are going to be done, and it is exceptionally costly procedure. If you do what I'm telling you to do today, a guardianship should never become necessary. Some of the forms you may be able to create even with your estate planning attorneys would be a pre-need guardian, where you're actually designating, in the event a guardianship is ever needed, this is the person who I want to be my lawful guardian. All of these written documents that I'm talking to you about should express your opinion. You should not be pressured. If you're going to an estate planning attorney to prepare these documents, if that estate planning attorney is doing his or her job, they're telling the other people that may be bringing you to their office to vacate that room. That's what I do. If you come with somebody and you're talking about estate planning documents, especially power of attorneys, I chase the other person out of the room whether they like it or not. And I can tell you, I've had people, when the other person leaves the room, tell me something different than what they said when that person was in the room. So the important thing for you to do is make sure you're having that conversation. You have the attorney-client privilege between you and the attorney who's preparing the documents, and that nobody is putting pressure on anybody to create a document. To make sure it says truly what the person wants. So it's best, as I said, to get these forms done early before you're in a weakened state and have anybody putting pressure on you to create and sign documents. As I said, some of those documents give a lot of power away that you may not want to give away. Do not rely upon others or expect the government to protect yourself. You need to protect yourself. The only way that you can protect yourself is by creating these legal documents. The government will do pretty much what somebody else probably wants because you're not capable of making that decision at the time. So do not delay, create the documents now to protect you for the future. Now, some other things I want you to talk about as part of when you're doing your estate planning is to think about what some of your needs and how can they be satisfied. Now, your estate planning attorney isn't really the person to give you advice on insurance. That's really more for a financial planner. That's not my expertise. But I can tell you that one way really to take care of some of these things is by buying disability insurance, which can take care of short-term and long-term care needs, or as long-term care insurance, which can sit down and help take care of things like at-home aids, nursing home coverage, and things along those lines. So if you have the financial ability, these are some other things that I would encourage you also to consider. One other very important document, which I think everybody should be aware of, is the most important asset I think that everybody owns, or at least a large percentage of the population own, is your real property. That's the property where you're living now. You do have the ability as part of your estate planning to transfer that real property by will. You could transfer that property as part of your trust by actually titling that real property into your trust. Or a document that I'm using a lot more now for many of my clients, which is called a life estate, which means I'll keep the property in my name, and upon my passing, it goes to my children. But a life estate also can be a dangerous document, because if it's just a regular life estate, you would need whoever that property is going to also sign off on the documents. So if anybody is ever talking to you, well, you should put your property into a life estate, I want you to think of a document that's a life estate, but it's a little bit different of a life estate. It's called an enhanced life estate, or it's also frequently referred to as a Ladybird Deed. And what that form of a transfer of your real property is it gives you the ability to still sell your property without anybody's permission, borrow against the property, take out a mortgage or reverse mortgage or whatever it is that you want to on that property, without having the permission of the people that get the property upon your passing. So I would encourage you all, if anybody ever talks to you about transferring your property into a life estate, to say no, but to consider the enhanced life estate, which is typically done in the form of a Ladybird Deed, that gives you the ability to own your real property, sell your real property, do whatever it is that you want, but upon your passing, to avoid probate for your real property and then to let it go to whoever it is that you want. Your children, your best friend, your local charity, whoever you want it to go to upon your passing. And with that, that's the end of my presentation. I'm here for whatever questions. I'm sure there's going to be plenty.
I heard you start coughing. I wanted to put on my mask.
Yeah, I don't think I can pass it through the microphone.
I don't think so either. But, you know, I wanted to be safe. I had to do that. So everybody should know, number one, Craig's in Miami and I'm in Central Florida. There's about 4 hours in between, but we're cool. All right, Craig, thank you very much.
Also, so don't worry.
Thank you very, very much for doing this conversation, right? Much needed, very much needed. For everybody to know, Craig, I have known for a very long time. He's actually a dear friend of mine these days, I think. I don't know if he thinks so, but he is. And he's also he's the attorney for MS Views and News. From the beginning, before we even got started, we sat at Craig's table in his kitchen trying to figure out what we're going to do to start an organization. So thank you, Craig, for everything. And
I think some people that, including my wife and I, were trying to say, why don't we turn this into a nonprofit and let's sit down and do all these things that we are now doing, which I'm proud to be a part of. I do consider you to be a very dear friend and a confidant of mine for, I don't know how many years now, probably close to 20, maybe more. I don't even know. It's been a long
like time. That, exactly. So anyway, thank you for all that talk. And boy, we really do. I got to get back in your office. We got to redo a lot of this stuff or start again, right? All right. Anyway, we're going to take questions. And before I get into that, I want to let everybody know that this, obviously, we're doing this program. We are video recording this. People are asking if it's going to be available online afterwards. The answer is yes. I mean, it'll be on our YouTube channel in about a week. All right. So we started the year off and we were going like gangbusters last week. And we have a lot of programs. I have maybe 1 or 2 videos to get onto our YouTube channel in advance of this, and then this one will be next. So people are asking questions, and I'm going to get into that right now. One of which is, all right, okay, let's start from the top of the page. All right. So Tina's asking, are there specific ages you should have specific things done with regard to the document?
The answer is, it's never too early to do an estate document. The problem is you always want to do it a day early rather than a day late. The truth of the matter is, I know people that have become disabled when they were minors. Unfortunately, a minor can't do any estate planning. So my opinion is the day you turn 18 is a good time to start thinking about it. I can tell you, I can remember my first day when I was moved into a law firm that I was working for. And I'm a young lawyer, practicing only for a couple of years. The last thing I'm thinking about is estate planning documents. And I'm brought into one of the senior partners' office. I figured it was really just to get to know me. And I felt like I was going through a Spanish Inquisition. And she started asking me the questions about my family, my children, and all of these other questions going through, and who would take care of my kids if something ever happened to me. And I'm saying, what am I walking into? But I also knew it was somebody I could talk to and trust at that point in time. And she says, you do realize what I'm doing here? I says, yeah. I said, you're trying to get me to do all my estate planning documents? She said, yes. Because the truth of the matter is, it's never too early to create it. But I can't tell you the number of bad case scenarios that I've dealt with in my lifetime as a lawyer. And this time she's probably practicing for 30 years or better at that time. And she starts talking to me about some of the worst case scenarios. And I'm saying, you know what? And I don't think it was more than 2 weeks after that, and I'm now in this firm only practicing for maybe 2 months, that she's dragging myself with my wife to come into the office and start signing all the documents and get them done. At that point in time, I've maybe 25, 28, somewhere around there. I can't remember how old I was, but I was a very young lawyer, but I already had 1 child at the time, and it was something that I needed to take into consideration.
Okay, thank you. All right, so next we have Danielle is asking, having MS, do I qualify for disability insurance or long-term care insurance?
The answer is maybe. It may be too late to qualify for long-term care insurance, but I would encourage you to go speak with an insurance agent, and you may have the ability to get some limited coverage. You may not have the ability to get everything. If you're part of a large employer group, you may have the ability to get it through an employer group, and it may not be too late because pre-existing may not matter. But I would encourage everybody to at least try to get it to whatever level you can get it, even if you've been diagnosed. Now, realizing there are many people, as it is multiple sclerosis, that may have their first event and not be capably being diagnosed with MS at that point in time, and may have the ability to get it because they haven't had the formal diagnosis.
Well, isn't, to go further on this question, isn't long-term care, once you're diagnosed with something, excluded and or super expensive?
The answer is to both, probably yes, but I would still try.
Okay. All right, great. Yeah, they're probably dying for money these days. They'll probably take it from you, right?
Everybody
Okay.
wants to make a nickel, so you never know what insurance companies do it. They may have, let's say, a 3-year pre-existing period, in which case after that it might be covered. You never know.
That's true.
What somebody's going to be writing, every insurance company is different. Even if somebody says no, I would still try somebody else.
Thank you. Keep coughing like that. I'm going to have to put my mask back on again. All right. Next, Cindy, I got the same issue. Cindy is asking, could you further explain the difference between a trust and a will, and why would a family member choose a trust over a will to pass on their monetary assets?
A will is a simple method of passing your assets once you pass away. That's all the will does. It transfers something upon your passing. A trust can be part of a will. I have what's called a pour-over will, where everything goes into a trust. Or a trust can be something that's even created outside of the will, which gives you the ability to transfer your assets into the trust. But the trust also gives you the ability to have decisions being made after your passing. What does that mean? That means I don't have to give everything to my child upon my passing. I may say that, okay, they're getting 25% at age 30, 25% at age 35, 25% at age 40, and 25% at age 50. You have the ability to control how your assets are going at certain points of time, so you can still, as I like better saying it, control things from the grave, which a will does not do. A will just passes everything upon your passing. A trust gives the ability to still control how those assets go at certain points of time, even after your passing, or to be even effective. I mean, I have clients of mine that have all of their assets pretty much in a trust that they still have the ability to draw and do whatever they want with during their lifetime, but upon their passing, there's no probate because everything's already in the trust.
Okay. All right. So you mentioned earlier something about an FMLA. Can you please explain what an FMLA is?
FMLA is the Family Medical Leave Act. It gives many benefits to people, which includes your people that maybe meet your healthcare surrogate. If that healthcare surrogate is an immediate family member, they may have the ability to sit down and take time off of work to help take care of you. It may also be rights that you have based upon an illness happening to you to be able to maintain your health insurance while you are incapacitated. So those are rights depending upon the size of your employer group that you may be working for, but it is an important thing for people to understand that they may have rights depending upon their health insurance, whether they be the healthcare surrogate, the person helping you, or to be able to get those benefits for you in the event you become incapacitated for a period of time. Sorry for my coughing.
Sounds like you need more water. For anybody that came into this program late, if you have a question to ask about anything to do with this topic, use the arrow at the top of the page in the red or orange box. Depending on your server, will depend on the color. Okay, next, a person is asking, how can I make sure that my boyfriend gets some kind of assistance for being my caretaker?
You have the ability to sit down and do a lot of different things. You can create a trust that gives that person some rights. You can sit down and have a life insurance policy upon your passing that gives something to your significant other. There's 100 different ways to do things. You can even have somebody in a paid position to take care of you. One of my favorite type of lawyers to refer things to is what's called an elder law attorney. Elder law attorneys are the ones that can sit down and help you qualify for Medicaid. They can sit down and help you, like a better way of saying it, deplete your estate and qualify for Medicaid legally by sitting down and saying, okay, now your boyfriend or whoever else it is being paid in advance for taking care of you. So there's a lot of different ways to do things. It's really something, if that's what you want to do. Simple ways are designate a life insurance policy, or to open up a bank account and give that person something that may take things out and have it jointly owned between you and your boyfriend, or speak with an estate planning attorney to come up with a lot of other ways to do things. The free ways, open up a joint account. Don't tell your boyfriend or significant other about that account until you want them to go have access to that money. But there are 100 different ways to do things. Those are the free ways. The best ways are really consult with a financial planner or a attorney to sit down and help prepare documents that can help you take care of what your wishes are.
Good, thank you. You just answered the next question. Somebody asked who they can speak with, and you just said a financial consultant or an attorney. So thank you for that.
Financial consultant, I always say go to a CFP, a certified financial planner, or go to a attorney. And I say not a drive-by attorney, which does everything. Find an attorney that truly does estate planning.
Okay, thank you. Next, the person is asking, do I need to add a do not resuscitate into a living will?
They're two totally separate documents. So yes, you should have both if that's what your wishes are, and if you qualify for the DNR order. Because typically DNR orders are something you're going to have also have signed off on by a physician, depending upon what state you're in.
Okay, next, the person is writing, so if you're married, your spouse doesn't automatically have the rights or power to do these decisions without all these documents? Question.
Most healthcare providers may honor your spouse's wishes. I do not like the saying when I have the word may. I like the word must. The only way I can assure that you have somebody has the power and that they're going to honor that power is to have a document signed giving that person the power. Will I say 99.9 times out of 100 will they speak to the spouse? I would say yes. But when it comes time to certain decisions, and I want to make sure that they have to honor that decision and not have the doctor making that decision, have the document. And that's the only way I can say that the doctor must honor or the hospital must honor.
Thank you. Bill is asking, can you put life insurance policy into a trust?
Yes. Let's say you have children. The children are not yet of the age of 18. How do you sit down and make sure that it goes to the child? You don't want the money going to the child. You want the money going to a trust for the child. That's just a typical way of doing it, which is something I've done personally for myself when my children were minors. So yes, you can sit down and have a trust be the beneficiary of your life insurance policy. It's also very commonly done for paying for those very wealthy people to pay for their estate taxes. They have what's called an irrevocable life insurance trust, solely for life insurance policies to pay the taxes on your estate. So yes, 100 different ways to do it.
Okay, next, the person's asking, how easy is it to change from one power of attorney to another if something goes wrong with the first person?
You go sit down and draw up the next one and you revoke the first one. Very easy. Takes 5 minutes.
Okay, next, Terry's asking, how soon does one need to have a trust completed before one dies? Probably before you die.
1 day, 1 minute. You can sit down and prepare a trust and unfortunately pull out of the lawyer's office, get into a car accident. It's still effective. Just always do it 1 day too early and not 1 day too late.
Okay, got it. Kevin is asking, does Social Security disability have different Medicaid requirements that regular Medicaid? I don't understand that, Kevin. You're going to have to write that back and let me go on to the next one.
The answer is you have people that qualify for Medicaid that do not qualify for Social Security disability. They're two separate and apart things.
Gotcha.
Social Security disability is Medicare. Medicaid, which comes from the federal government. Medicaid comes from the state government. So you can have both. You can have one and you can have the other. I've seen people qualify for Social Security disability that do not qualify for Medicaid. I've seen people qualify for Medicaid that do not qualify for Social Security disability.
Okay, next, should I get a life insurance policy? I'm worried for my son after I pass.
The answer is yes. Life insurance is probably the best vessel for passing wealth outside of your house. So I encourage everybody to have life insurance. I mean, I make no money off of it, but I think it's a great method. I also find it to be a great method, what I call forced savings. It's very easy to spend your money, but it's also very easy to sit down and buy life insurance. Life insurance can be a very cheap form of passing a large amount of wealth if you do it early enough before you have conditions that make it too expensive, or it gets to be too old, or it gets to be too expensive.
Okay. Next, I'm a social worker who works with MS patients, and I just need to know what kind of financial responsibilities I need to know more about.
Well, as being a social worker, you have no responsibility to anybody other than to sit down and comply with your ethical obligations. The trick is to sit down and possibly, I mean, it's not something that I've seen many social workers do, but I think it would be good for social workers to at least encourage people to understand what the risks are of not having documents done and to encourage them to seek out professional advice. I would encourage a social worker never to recommend anybody in particular, other than to encourage somebody to seek out proper guidance to get the documents prepared.
Great, thank you for that. Okay, next are there better life insurance companies for people with MS-related issues?
I would say that's really something you should go speak with your certified financial planner or your insurance agent to discuss. I can't tell you who's better than the other as far as life insurance. That's not my expertise. But there are lots of people out there that just because you have MS does not mean you will not qualify for life insurance. And I think too many people think that because they have something that they cannot qualify. That's not the case. I mean, it may be the case, but it's not always the case.
Okay, next. What if you are unemployed or stay-at-home parent? Can you get any disability insurance or long-term care insurance?
Absolutely. Go speak with them. I mean, you don't have to be employed in order to sit down and get the ability to have benefits. I mean, okay. I know people that are stay at home, you can still buy a life insurance policy. You may not be able to get as much as you want if you don't have the income to substantiate, to justify it, but you should still have the ability to get some.
Okay. I would think that just if you had the money to pay for it, that they'll let you pay for it. Is that not the case?
Many of the insurance policies have financial thresholds based upon your income as well, because they may not want somebody getting a $5 million life insurance policy when they only earn $25,000 a year. Just because you pay for it doesn't mean that they will actually issue it to you. And they don't want to actually encourage people to sit down and find ways to become disabled or die in order to get benefits. So.
Okay. I just want to remind everybody, if you have any questions, we're running out, okay? I've only got 3 more left or 4 more left. But if you have any questions for Craig, please type them in, because, you know, once we close this program, you can't ask Craig any more questions. All right. So it's like that doctor's office thing. You know, once the door closes, you're done. But right now you have time. So type. Okay. Next, person is writing or wrote, interested in financial planning for the uncertainty. Can you give me any clue what I can do?
For me, my first form of financial planning is to sit down and do everything that is free. What do I mean by that? What I said at the very early part of the slides. Go to your bank, make sure you have beneficiaries that are designated. All of those things. That is financial planning 101, and it's free. That way it means you don't have to worry about where my assets are going to go, God forbid something ever happens to me. And why should I have to sit down and pay a probate attorney for a relatively small estate to sit down and take care of things that I can do for free? The other things are, I mean, you can sit down and do a whole bunch of other things, which is to go speak with an insurance agent. Insurance agents don't charge any money. They're commission-based. A certified financial planner will charge you money. But if you go speak to your local State Farm, Allstate agent, whoever it is that does your insurance, there's a lot of the estate planning aspects you can do and financial planning you can do just through the form of insurance without paying anybody to consult to get those things done. So where to say? First, deal with your banks. Those are all free. Second, talk to your insurance agent and get some ideas from them as to what you can do for financial planning, all at no cost. There's nothing better than getting things for free.
Very, very true. Thank you for that information. Next, we have need information on long-term care for a child with PPMS, relationships or caregivers, and a client.
I can't guide you to anybody in particular, but I can say for long-term care insurance, again, just go talk to your insurance agent. Whoever takes care of your homeowner's insurance is also licensed to sit down and do disability insurance, or will refer you to somebody. Life, health, and long-term care is done by almost every person that also does your regular insurance. So go speak to them, and that's the best method for doing that. As far as for recommending anybody, I do not recommend anybody for anything. So that part I do not do, but I encourage you just to go talk to your general insurance agent. And if they don't do it, rest assured they have a colleague that they work with that will do it for you.
Okay, thank you. Deborah is asking, can you talk about an able trust if you've not discussed it already? Thank you.
I mean, to me, I'm not really sure what you mean by the able trust. I presume you're talking about a general revocable trust. I mean, you can create a trust for whatever it is that you want. You can put whatever you want into your trust. The question is, what do you want to put into it? Trusts are just there. I've had people that have trusts for the purposes of owning a condo. I've had people that own trusts for owning motor vehicles. I mean, it's crazy what you can put anything you want into a trust. You can have as much in it as you want. You can have 14 different trusts. So a trust is a vessel for holding ownership to something, and that's all it really is. The question is what you want to put into it, how you want it to operate. There are trusts that are created which are called irrevocable trusts, which are done for asset protection. Again, this is a method of something that you need to talk with whoever is going to handle your estate planning. It should be somebody that is a specialist in handling estate planning issues. And every trust is not really a form. It's a matter of what it is that you want to establish and create by it.
Okay, thank you. Bill wants to know if a Ladybird trust is the same as a revocable.
A Ladybird is a deed. A Ladybird is not a trust. A Ladybird deed is a method of owning real property and passing it outside of probate. It gives you the ability to sit down and still sell it, do whatever you want with it during the course of your lifetime, but upon your passing, it automatically goes to whoever gets the remainder of the property. But a Ladybird is not a trust. A Ladybird is a deed, and it's solely for the purpose of real property. A trust can be for real property, personal property. It can be for anything. It can even be for the holding of the rights to a website. I mean, there's no limit to what a trust can own. Trust can own real property, but the deed is only the deed for the real property that you live in or own.
Next, we have Darlene. I'm a retired teacher in Ontario with a will with my husband. Should I also have disability insurance? I have MS for 48 years.
I would encourage anybody who's eligible, who has a medical condition, to attempt to seek out to get whatever types of insurance you can get, whether it be disability, long-term care, or anything else, in order to protect from the situations which, from almost everybody, it's an inevitable thing as we get old that eventually we're going to need to have somebody to help take care of us. So if you qualify for it and you are capable of getting it, I would encourage you, yes, to get it. The will has nothing to do with anything other than the passing of your estate upon your passing. So I would encourage you to seek as many forms of protection for your assets, to make sure your things go where you want them to protect you in particular from others, by having these documents created in order to make sure that your wishes are taken care of. But if you can get insurance, I'm a big believer in insurance to get for whatever you can, whether it be for your home, whether it be for your car, or whether it be for yourself. Because eventually, when we're not able to take care of ourselves, somebody's going to have to take care of us. And it's good to sit down and not have to put that pressure on our family members if we can get professionals to take care of us.
Right, thank you. Kevin wants to know, are there MS specialist estate planners?
I am unaware of anybody in particular that specializes in doing estate planning for any specific disease. Whether it be cancer or whatever else it is, I think if you find somebody that's qualified to do estate planning, regardless of what your condition is, they should be capable of giving you decisions that would help you when you express what it is your desire to accomplish. So I would encourage you to, one, seek out an estate planning attorney, and two, if you are in a extremely bad condition or state, to go the step further to get an attorney that's not only an estate planning attorney, but what's called an elder law attorney. It doesn't mean you're older, it just means that you're more infirmed, in which case it might be best to seek with somebody that can also help you when it comes to qualification for Medicaid and dealing with a more severe state of your condition.
Thank you for that. Next, there are a lot of people saying thank you, Craig, so I just want to let you know, thank you, Craig. All right. Next, we have Kay. Kay is asking for you to please explain what an advanced directive is versus a living will, and when would she need one, and how long do they last?
A advanced directive includes a living will. It's just a more broad form of talking about a subject matter. Advanced directives are just methods of dealing with things in advance. That's all it really is. And we're dealing with those things there. So a living will is a type of an advanced directive. A DNR is a type of an advanced directive.
Great, thank you. And Kevin, thank you for your kind words, and I'll let Craig know later. Well, I'll let him know now. He wants to say thank you also, okay? All right, next, we have Tina. Tina is the last question that we have tonight, okay? So, Tina, how do you get yourself over the fear of doing all this? We know it's what's needed to be done, but it's quite emotional. Are there ways to break up things so it's not so overwhelming? What first, then next, group, etc.?
What I would say is the first method of doing things is start with the free things, which is to go deal with your bank accounts and start taking care of that. It's the first step. It's not a cheerful concept to go over to your banker and say, you know what, I need to want to put a beneficiary on my account for when something bad happens to me. That's the first step. It's taking things in baby steps, but the truth of the matter is, I would never want you to go to a financial professional and have one document done and not have all of the documents done. Lawyers in particular charge for their time. That's the only way that a lawyer gets paid. We don't sell a good, we sell a service. So the best way I can say of getting over it is saying, okay, if I go to my lawyer to create a will, and then I go to my lawyer to create a power of attorney, and then I go to my lawyer to create a healthcare surrogate form, that means I paid 3 visits to my attorney. That means it's going to cost you that much more to do. So the way to say to deal with the concept and the emotion is think with your pocketbook, saying if I'm going to go do these things in baby steps instead of doing it all at one time, it's going to cost me a lot more. So it is a morbid concept. I can tell you there's been times when I've been meeting with my clients and I'm borderline in tears with my clients when I'm sitting down and doing these things. And I'm not the most emotional person in the world, as Stuart I'm sure can tell you. That's not who I really am. But you have to have a lot of empathy when you're dealing with people, because this is not a cheerful subject. I said right at the very beginning, this is a morbid subject, but it is a very important subject to deal with. That's why I think Stuart has brought me a few times to have these conversations. People that have MS need these documents more than others. But the truth of the matter is, your caregivers that may be in perfect health need the documents as well, because we never know what's going to happen tomorrow.
Tina, it's worse. One second. Sorry to interrupt you, but Tina, it's worse to figure out what you're going to do with yourself afterwards, and you have to have that planned beforehand. So that's even more difficult.
So I say break the ice by talking to your banker. That will be your first baby step, because that's free. It doesn't cost you anything, and you're doing it, and you're having to realize that, yes, I do need to do these things. And I'm sure even your banker will say, yeah, I'm glad you're coming over me and we're doing these things now, versus you having to go hire a probate attorney and pay a whole bunch of money to do things that you can pass for free.
Yep, and a few people have answered, yeah, it's very true about what to do it yourself for the post rather than the pre, right? That's very difficult. All right, well, Craig, thank you very, very much for being here. Kudos from many that were online tonight. I'm sure everybody does, but they're being a little bashful. And look, we can't wait to have you again for another talk, and we can make this happen at the end of 2022, all right?
You can call me anytime. Glad to be there. I apologize for everybody in advance for the extra coughing, but have a little bit of a cough hanging around, and
you don't always answer the phone like every other attorney. All right.
What was that question? I didn't hear that one.
What's that?
I didn't hear that last question.
I didn't say it was a question. I said you don't hear the phone ring a lot of times like a lot of attorneys.
I still didn't hear what you just said either, so don't worry about it.
Okay, got it. Let me rephrase that. Okay, no, I won't do that right now. All right, everybody, thank you very much for being online. We look forward to seeing you tomorrow night for those of you that can attend, and or Thursday night. And for now, we're just going to say thank you again to Craig and have a wonderful evening.
All right, thank you for having me here, and thank you to BIOGEN for sponsoring.
Thank you.